table is my brother Ken Dandar. We represent the appellant, Artis D. Carter II, as personal representative of the estate of Lisa Marie Yvette Carter. And I reserve 5 minutes for rebuttal.
So can I start with a question, if you could introduce yourself? What happened with the original appeal that was reversed on the Fabergé issue? Was a rehearing filed for better instructions? Because it came down to instructions, didn't it, on remand, new trial and damages, new trial and apportionment, new trial and liability, everything. What happened?
The last appeal said it was a Fabre error. They had to go back, we had to go back and they were allowed to apportion the fault of the ICU. And that's what was supposed to happen, but
how do you
a new trial, all issues.
How do you know that was supposed to happen? Is it in the opinion?
It's not in the opinion, it just says it's Fabre errors, and if you look at all the cases on Fabre errors, it says you don't go back on liability, you don't go back on damages, you have a trial on apportionment of that third party.
You went through the whole trial and you had a whole new trial.
We ended up having a whole new
I
trial.
mean, normally you don't get to second guess the verdict, you live with it or you die with it. If you had a problem, you do it up front. You file for clarification in the appellate court, or you get instructions from the trial court. There must have been a discussion at the trial court where the judge said, hey, I'm giving you a whole new trial, and then you guys lived with it and you had a whole new trial. Is that wrong?
Well, there was motion for rehearing before this court, which was denied. And I believe there was
Rehearing or
also,
clarification.
pardon?
Rehearing or clarification.
It was a motion
Who
for,
filed it?
Mr. Vodka filed it, the appellate counsel.
Okay. So he wanted clarifications for the remand as to what would happen.
I believe so. I don't have that
So in other
brief
words,
with
there
me.
was doubt as to what would happen. And then the trial court discretion what to do on remand.
Well, discretion, in my opinion, discretion as what the law says, all cases say you don't retry damages.
Well, why didn't you file a rehearing if you didn't have any doubt as to what happened?
Because the decision didn't say anything. It didn't say
Well, it said a
anything.
lot of stuff. It didn't say the remand instructions you were hoping to have. And the clarification was denied, or rehearing was denied.
Right, and that appeal started off by saying, the USF saying in the first line of their summary of the argument, that this case is not about any standard of care breached by USF. That's been determined, basically. They said that. And then it went on, and this court went and recognized, they said, well, the initial injury of the heterotomy was not negligence, but the failure to discover it was. Yet it held there was no initial tortfeasor. USF was not initial tortfeasor. Go down and do the Fabre, see if they're joint tortfeasors, which instructions never, the court never approved my instructions. They use other instructions that don't separate the dates so that we could find out initial tortfeasor or joint tortfeasor. And then we went and they bring in a new expert who gives 4 different initial torts. One was the failure to discover the heterotomy before closing, failure to give antibiotics while she was still in exclusive control and custody and treatment by USF physicians, failure to have an abdominal CAT scan, and the last one was the, what's my mind? Call a surgeon. Call a surgeon. When she needed, she had a rapid response team came, which is all USF physicians. They did not call. He said, I'm not going to call a surgeon at 10 o'clock at night. He waited until 4:30 in the afternoon of the next day. I'm not going to call him 10 o'clock at night. USF is contractually obligated to provide surgeons 24/7, 365.
There was expert testimony that you would not call a surgeon in unless the patient was stabilized, which she was not.
But that's up to the surgeon to determine that. And then also the antibiotics was never given. And Dr. Gleason said that was a first priority.
I understand what you're saying. It just strikes me that you're arguing your facts, and there was another set of facts presented, and the jury made its decision.
The facts I'm relying on are all facts from USF's physicians. Dr. Streisand is their new expert for ICU. He confirms the 4 initial torts. Dr. Glazeman,
Well, the fact is, we're arguing facts. And as I see it, the jury heard two different stories.
well, the only
I'm
other,
trying to figure out what the legal error is.
the only other story they heard was USF's Dr. Margolis has said this opened up all by itself post-surgery. Dr. Systrom said he had a case just like this before, where the enterotomy, it goes undisclosed for a little bit, but then it was a rapid progression of infection. And he called this a rapid progression of infection.
Mr. Dendar, your main point that you're arguing here was this case got reversed by our court and got sent back without a detailed instruction as exactly why it's going back. And as a result, an entire do-over was done. And your position as the case law doesn't support that. That's the legal error that you're arguing, correct? That it
Correct.
should have only gone back on the issue of the fabricated defendants, correct?
Correct.
Help
Whether
us
they're
with
allowed-
that law. What's your best case to support that?
The best case to support that is the Nash case, Supreme Court case, which was brought up on the motion for rehearing. And all the cases that follow that. I mean, I have in my brief, all the second DCA cases. I mean, there's numerous from other, there's no court that says otherwise.
Okay.
No appellate decision says otherwise. No goes back on the apportionment of, I'll say causation apportionment, whether the third party was caused any damage and what's the apportionment, what percentage. That's the only thing it goes back on. All cases say that. So I'm assuming that when this court had this decision, it's gonna have to instruct the lower court because that's what all the cases say.
And in the court below with Judge Nash, I believe was the presiding judge.
Yes, that was a new judge to the
You
case.
made this argument to him at that time, correct?
Yes,
In the trial courts.
yes,
And he basically found a way to deny that request.
yes. He read the cases exactly the way I said. I quote him in my brief. He found that that's what they say, but then he said, we're gonna have a review USF, let's have a new trial on everything. And the only reason they gave when they appealed is they wanted to read the deposition testimony of Dr. Angus, which was an ICU doctor we used in the first trial. And we didn't read them in the third trial.
I thought, Mr. Dantar, that if I read the record from the other side's briefs correctly, there was more than just an apportionment issue that needed to be addressed on review. Am I correct on
They always said apportionment and causation. But it's the same, apportionment is what the percent, causation is did they cause anything? Did the ICU cause any damages?
that? Well, don't you need to start from scratch if causation remains an issue?
No, because we got 3 different days. We got the causation of the USF on day 1 during the surgery, causation of USF still on day 1, failure to recognize as an infection. And then day 2, they failure to do the infection, abdominal CAT scans, things of that nature.
Yeah, but I'm having trouble figuring out if we have 3 different levels allegedly of reports. I don't see how you send it back on remand and say that there's only an issue of apportionment. Don't you have to establish who caused it? Because we're starting from scratch, apparently after our decision came down.
But again, your decision includes the fact that failure to discover the enterotomy before closing surgery on November 1st was a breach of the standard of care. It says that right in, but it doesn't say that negligence is established, even though USF in their brief said, we're not arguing standard of care of USF. We just want the third party.
That's not binding on the judge or jury.
Pardon?
That's not binding on the judge or jury. They still could have found no liability, correct?
Well, when you retry something like that, yes, but you're not supposed to under Feb.
I understand you're not supposed to do this, not supposed to do that, but we're dealing with what happened. So if there was no liability implied, then it doesn't matter about damages unless there was some other legal mistake.
The last thing you said, some legal
Unless
mistake.
there was a legal mistake, like you're not supposed to redo this whole thing.
Well, that's the first legal
But the
mistake.
case, like Nash, the cases you cite, did they come to those courts with the same ambiguous remand instructions as was in this case? Or did they have clear instructions and the court went off the reservation, so to speak?
I do not remember. I could submit a
No,
memo
no,
on that.
It's just a fair question, but you move on. I don't want to take up your time.
Okay. So anyway, the last appellate court did not have all these admissions. We've been fighting for trial on septic shock since the first trial. And Dr. Sistrom and Dr. Glazeman, they all agree, and the other doctors all agree that she had septic shock. She was in septic shock at the time the rapid response team, USF's rapid response team arrived at her bedside on November 2nd at 9:45 in the evening. So they should have administered antibiotics at that time, and they didn't do it. Instead, they put her to the ICU, which is an open ICU. They could have administered it then too, all that night that they were taking care of her, but they didn't do it. But the Dr. Sistrom said the critical time was within an hour of the opening of her umbilical incision when all the blood came out, and that was the time that the USF should have administered antibiotics. And again, Dr. Glazeman said that was a first priority, but he didn't do it. So and the surgeon, calling the surgeon, there's ample testimony on that, is the surgeon makes the decision whether or not to do the surgery based upon the condition of the patient. The surgeon has to see the patient, she has to see him. And because of this new evidence, the other prior opinion, Carter 2, said that Stewart didn't apply because there was no initial tort. But there was initial tort. Now we have 4 initial torts confirmed. So Stewart does apply. USF is liable for everything that the ICU may have done wrong, which they're trying to say because they didn't administer antibiotics, but they empirically did it. When USF refused to do it that morning, they said, we're just going to do it. Their own expert said, that's what it means. We're just going to do it. Not supposed to, because the form says USF, first team, primary team, is responsible for administering antibiotics.
I hate to keep pounding on this, Mr. Danzar, but what I'm hearing is your understanding of facts. And there's just, he's going to get up and there's going to be a different set of facts that were presented. And I come back to the point of the jury weighed what it heard and came to its conclusion as to liability and damages.
Well, the jury wanted to see the USF, the Tampa General Hospital rules and regulations, which shows that the attending physician's responsible for the entire care throughout the
So
ICU.
that was left out, as I understand it, for lack of an evidentiary foundation to allow it in. Am I correct as a trial?
That's what the objection was, and it was sustained,
Okay.
even though the document is a USF document, because it's attached, it's incorporated in their affiliation agreement. The only reason USF has the only reason Tampa General is a medical training school is because they have an affiliation agreement under statute that gives Tampa General immunities, protection, because they place all the blame on USF. And in this case, once Tampa General got out, USF said, well, let's start placing the blame on people in the hospital, like the ICU. That's what happened in this case. But legally, it should not have happened, because there's the only time they could possibly be joint tortfeasors is when it's in the ICU, and we have all the negligence before that. So legally, that was incorrect. USF has to be responsible, is responsible under the law, under the contract, because they're the attending physician, they're in charge of her care, even though they use consultants. That's what ICU's called, a consultant, to do the vasopressors, because they're the experts on that. And everyone's testified. That's why she was transferred there, to keep her oxygen level of 92% and to stabilize her blood pressure. And ICU did exactly that, stabilized her blood pressure and kept her oxygen levels up. They weren't there to administer antibiotics, because even the form says you don't do it. USF's responsible.
The expert said the contrary.
No, the expert agreed. He agreed that the contract paper on the consultation says USF is the primary team, antimicrobial medicine.
I thought there was expert testimony that ICU team should have administered antibiotics.
That was said, but that's not what the contract is. The consultation agreement. This case has always been decided on contract. Tampa General got out on directed verdict because of the admissions form and because of the relationship with the USF. They got out on contract.
Mr. Agenda, I don't want to interrupt you. You have the 5 minutes. You can keep going or you can save it.
I guess we'll save it, Judge. All right, sorry.
All right, thank you, sir.
Chance Lyman on behalf of the Board of Trustees of University of South Florida.
So, Mr. Lyman, the overwhelming weight of authority seems to say that this case should have only gone back on the Fabry defendant issue.
I respectfully disagree, Judge
I
Morris.
figured you would. That's your time to tell us
I
why.
think you know that. So I have a couple of responses to that. I think the easiest one is, as Judge Valenti acknowledged, that was decided on rehearing, on clarification, and it was decided adverse to the appellant here. So that's a bar to any retrial argument that the remand was unclear or that the remand was somehow limited. I mean, that's a law of the case argument that I think resolves it completely independently.
Whether you like it or not, you're stuck with it.
That's correct. That's correct.
Well, what about the Nash case, the other case he cites that say you still can't do that?
So putting aside law of the case, we have the fact that it was not a limited Fabry reversal. That's what Nash is. It's a limited Fabry reversal. This court's opinion is fairly clear. It's divided into subsections. It clearly reverses on an empty chair argument and a Fabry argument. We made that argument in the last appeal that the significance, as Judge LaRose alluded to, when you're arguing about a sole causation issue, that requires a remand, a retrial on all issues. That's not an apportionment issue. That's not a Fabry
So
issue.
let's say on remand, this was a $125 million verdict. Would your argument be different today?
No.
It would be conceding error.
No, I wouldn't. Do you mean a $125 million verdict against
Against
USF?
USF.
Well, I certainly would not argue that the remand was limited to the 109
I would
million.
doubt that we'd be here.
I'm sorry, Judge.
We probably wouldn't be here.
Maybe.
Unless you all had some reason you wanted.
We might. It could have gone out that way. But so other than the fact that it's not just a limited reversal to Fabry, there's also case law now. The Crime v. Looney case I would direct your honors to. That's out of the first DCA. That makes the point that really maybe wasn't clear in Nash, but is reflected in Nash, that when it's an error that starts before trial, that affects all of the evidence that's presented at trial, that means it's intertwined with the evidence. And that's essentially an exception to the Nash rule. Certainly that's what the crime case has decided. And I recall we cited case law in our prior briefing. I think it was a R.J. Reynolds case that discusses this intertwined evidence issue. And when that's what the error is, which certainly applies in the case of the reversal on the exclusion of expert evidence about another provider's sole proximate cause negligence, that's what requires a complete retrial on everything. So even if we weren't talking about law of the case, and even if we were just talking about what does Nash mean, Nash doesn't mean when you have an error like the one that occurred in the third trial, you stay with the damages verdict. There's no case law that says that. And of course, Crime v. Looney now has clarified that, and to the extent there is any ambiguity there, this court should certainly follow the lead set in Crime v. Looney, and it's consistent with actually statements of Nash.
Let me shift gears on it to a different
Absolutely.
issue. The jury in this case failed to award even nominal past economic damages based on the evidence and testimony that was in this trial. I
Yes,
mean, there was cases that say that in and of itself isn't supported by the weight of the evidence and a new trial is required.
So few responses to that. That's the inconsistent inadequacy argument, right? And well, our position is, of course, that's an inconsistent verdict because we've actually cited the only case, and there was no response to it in the reply, where there's a zero on one side and numbers on the other side for all of the categories of past and future. Now, certainly decisions like this court's Arias decision, where there are some in past, for example, past medicals, but not past non-economic, absolutely the law does imply that that would be a situation where there does need to be an additor to the non-economic past award. But that was not what this verdict was. This verdict was actually inconsistent because it was all zeros on past and all numbers on future. And that's the Hendelman case that we cited. Now, of course, it's a concurrence, but it has been followed by other decisions as well. And as far as the research goes, it's the only case any party was able to locate where there's all zeros on one side and all numbers on the other side. So that's what makes it inconsistent. And obviously, there was no objection to the inconsistency, meaning that issue is unpreserved. Now,
What about the failure to admit the policy and procedures that would show the connection between these parties?
so the TGH rules, as Judge LaRose alluded to, that was an objection based on a lack of foundation. It was sustained. There's no argument about that objection in the initial brief, so that's waived. But even on top of it, basically, that testimony came in anyway through Dr. Glazerman. Dr. Glazerman answers a question, yes, that he is the attending physician. But the point is, there's other expert evidence that shows that other doctors were responsible for administering antibiotics. Dr. Systrom at the record 2713 through 2719, that's the proximate cause testimony from Dr. Systrom, and that's the missing link. Tying in this issue with the initial breaches of care that would essentially trigger Stewart, setting aside for a moment that argument is not preserved, the argument that Stewart applies to this case is not preserved. But the reality is, none of those initial torts, as they're being called, are initial torts because there's not a proximate cause connection to them. I mean, even if there was a proximate cause connection with them, Judge LaRose, as you alluded to, there's conflicting evidence on that issue. And this comes all the way back to, well, the case law is abundantly clear that the jury's verdict has the presumption of regularity and the presumption of correctness. Now, what that means is all the evidence is construed in the light of upholding that verdict. And that's really what the case law says. I know there's some debate about that in the briefing. And I just point out to your honors, the Oliver case that's cited in the reply brief for the proposition that the appellant here is a prevailing party, that's not what Oliver says. It does use the term prevailing party, but I think in the very next sentence of that opinion, it talks about construing the evidence in the light most favorable to the appellee. That's USF in this instance. And that means that Dr. Systrom's testimony, which is frankly the only testimony that gives a proximate cause link to the events in the ICU, that is what controls here. And we can't really debate and look beyond that and talk about the other records that may have said something different, because that is the evidence viewed in the light most favorable to the jury's verdict. So, the antibiotics issue, that's what's covered by Dr. Systrom. Dr. Systrom says there are records that show the ICU team is administering antibiotics. Again, just like in the last appeal, there's a critical moment, the evening of November 2nd. That's when the patient is in the ICU. And that's when, if antibiotics had been given, none of this would have happened. She would have stabilized. Judge LaRose, as you acknowledged, there would have been an opportunity to call a surgeon. That's why it is the critical proximate cause issue. So that alone dispels the notion of initial torts. It dispels the notion that there was some kind of manifest weight of the evidence issue here. And really, it just, the evidence has to be viewed in the light most favorable to the jury's verdict. And that resolves the issue. Other than I think we've pointed out here that most of the arguments being made in the initial brief are unpreserved and they're frankly just not briefed enough to respond to it. Going back to the point of the scope of the retrial, that there are just so many different ways that is resolved adverse to the appellant here. And really, that is the main argument that's being made. And it also, I just want to say too, the motion for additor was not a proper motion. So this argument about an increase of the past non-economics award, it's also unpreserved for that reason as well, because even if you just consider the common law standard, which is the only one that could even possibly apply, it was just an argument that the $109 million from the prior trial needed to be reinstated. The fourth jury didn't hear about that verdict. So that's not even evidence in the case. So this verdict can't be against the manifest weight of the evidence, because That was not evidence in this case.
As we sit here and talk about these legal issues in this trial, it's very difficult for me to put out of my mind what a tragedy this entire thing was. What a terrible ordeal this poor lady went through. And I just felt I had to say that. We were just talking about legal issues. This was a real human being who had a very tragic situation happen.
Absolutely, Your Honor, and there's no debate about that. There's no debate. I do want to correct one statement from the initial presentation. USF has never admitted to causation and liability. There's never been an admission. There was not an admission in the prior appeal. USF absolutely contested that USF breached the standard of care at all in this case. We've absolutely contested that. There was contrary expert evidence that says there was no breach in the duty of care by USF here. So that's always been USF's position. Now, unless there are any other questions, I'll just end by saying a $21 million verdict, Your Honor, that's not an inadequate verdict. And there's no evidence in this record. There's no argument on this
Certainly
record.
different than 109 though, isn't it?
It is, but Your Honor, as this court rightly decided in the prior appeal, that was not a verdict obtained with due process. And that was because USF was prohibited from arguing its causation defenses. And that's why the case law says when the jury is inflamed or prejudiced, we have to have a new trial. So that's the law. And I think that that's absolutely consistent with what due process and the Constitution requires. Thank you.
In trial number 3, where the $109 million verdict came, USF didn't argue damages at all. So for them to say that it's excessive now, it's talk about waiver, it's waiver. They should have presented something. But they did present Dr. Systrom that said, first of all, he says in an adequate verdict, this court in Next Lube, 2021 case, not a 1992 case from the 4th DCA, 0 award is inadequate. Inadequate as a matter of law, not inadequate as they argue the word inadequate. Trying to say 21 billion for loss of hands or loss of legs below the knees and the stomach muscles and all that she went through. 13 surgeries in the past, pain and suffering for all that. Having to deal with, they tell you, your hands are gangrene, your feet are gangrene, we got to amputate them. Have to deal with all that in the past. 0 is inadequate. We also had an additure. They tried to say the motion was wrong because we only referred to the prior verdict. Well, we have a prior verdict. We have numbers. So we ended up in following it. We supplemented our motion for additure. We supplemented it with the actual verdict and the, I believe even the judgment. But we supplemented that. So those are the numbers. So bring it before the new judge, Judge Nash, so he can see that right there. Empty chair. They never, ever argued empty chair. They always wanted the ICU on the verdict form. And it was error for the judge not to put in the dates, to use my verdict I prepared for November 1st, 2nd, 3rd, because this court in the prior appeal said we got to determine if there were joint tortfeasors. The only time you can have a joint tortfeasor is in the ICU. And yes, the ICU administered antibiotics because USF didn't before she arrived there. And their own expert said they should have done it before she got to the ICU because she didn't get to the ICU till about 10:45. It was 9:45, 9:50 when they were there seeing this blood coming out of her incision that they should have known. But even before that, when they took her from PACU to 7C, it's in the notes. Her greatest risk is infection because that's when her blood pressure was dropping and she had to go on the ventilator and she had to get bolus, which is fluids to build up her blood pressure. And that didn't work. Anyway, this court should reinstate the prior verdict, prior judgment, because it was error to have a new trial, a do-over, and And there's no law, there's no case law to support a do-over trial. It's contrary to the law to have a Fabry error and then say, we're gonna have a do-over and everything. It's only supposed to be apportionment and apportionment and fault causation. But since we have it was also error not to admit the TGH rules, which is a USF document because it's attached to the affiliation agreement. It was all proven up in the first trial, deposition of Dr. Houston of Tampa General, and it was used in the prior trials. But which we had to get orders to get the documents, the exhibits moved over for trial to trial to trial with the clerk. They had to take them out of storage. So many legal errors in this case will result in a manifest injustice to my client. Thank you.
Thank you, John. A lot of you. Have a great day. We're moving on to Timco. Is everybody here for Timco, both sides? Stand by. Are we missing someone? So if we're missing one side,